Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our first case this morning is Noble versus Foxmoor Group LLC et al. And we will hear from the appellant.
Thank you, Chief Justice Newby and fellow justices of the Supreme Court. Good morning, may it please the court. My name is Amanda Bryant Mason, and I represent the appellant in this matter, Ms. Loretta Noble, who does in fact pronounce her name Noble as opposed to Nobel. I would ask the court to reserve the standard 5 minutes for rebuttal in this matter. I ask this honorable court today to reverse the Court of Appeals ruling that the Unfair and Deceptive Trade Practices Act of North Carolina, which I may refer to as the Act for today's argument, does not apply to the subject transaction of this case. This matter involves monies given by my client to the appellee in reliance upon misrepresentations about the nature of his business. Of the 3 elements required to be established in order for the Act to apply, it appears only the second element is in doubt at this time, whether the subject action is one in or affecting commerce, according to North Carolina law. The phrase in or affecting commerce is a broad phrase with one narrow statutory exception carved out for professional services. The court should find that while other exceptions have been carved out, they are narrow and apply to scenarios with a significant insider quality. In this case, no insider characteristic exists to the underlying transaction, and the Act should apply. Notably, the Court of Appeals is inconsistent in its characterization of this transaction, first referring to the contract between the parties as a loan, and then later in discussion referring to the contract as a security instrument, and therefore ruling that the Act does not apply. And the difficulty in categorizing this transaction is understandable and goes to the heart of why the Act should apply in this case. Probably it is easier first to define what the Act does not cover. First of all, as mentioned, the plain language of the Act precludes it from extending to professional services. In addition, as aptly noted by Judge Arrowwood in his dissent, the Act does not cover ordinary employer-employee disputes, such as those referenced in Buie versus Daniel International. Again, that is an insider character to that transaction. The Act does not apply to securities transactions, such as those referenced in Skinner v. E.F. Hutton and Company, or wrongs between partners in the same company for wrongs that, quote, only affected that company or its co-owners, end quote, White v. Thompson. As the court is aware, Loretta Noble was not an employee of Foxmoor. She was not an insider in any sense, not a co-owner nor partner of the company, and she was not the holder of a corporate security, such as the type referenced in Skinner or the Hodgem case, upon which the Court of Appeals majority relied heavily.
Ms. Mason, you had referred several times to insiders. Is that term used in our case law under GS 75-1.1?
It is not referenced in the statute itself, but it is referenced in multiple cases. Notably, I would reference to the court, the term is, well, Your Honors, I can't point to a specific pin site where that word insider is used this morning, but I think if the court were to review the cases presented, what it really references is we look to a company like Alexander or a case like Alexander versus Alexander, which references a single market participant. What we're dealing with is 2 people or 2 entities within one entity. If we look to Skinner versus E.F. Hutton, again, we're dealing with an actual owner, someone who is a participant within the actual company itself. With regards to Hodgem Company, which is the case primarily relied upon by the Court of Appeals, we're dealing with an actual corporate issued security. It is something that was reflected in the actual corporate books as an ownership type of security, as one would typically expect to see. And then in addition, in White v. Thompson, I believe that what that case stands for is the concept of internal operations, that we're dealing with welders who were all owners, had ownership interests within the same exact company.
So is it your contention then that the act applies unless the plaintiff has some sort of ownership interest in the business in question?
I believe that I believe that the way to review this particular statute and this particular element of the statute is narrowly in terms of what is excluded. This is a very broad statement in or affecting commerce, and the way the cases have interpreted it is to look for the exceptions. And in all of the exceptions that I have reviewed, there is either that specific ownership interest that Your Honor was just referencing with regards to a standard corporate security type instrument, or the exception would be for an employer-employee type of transaction, or specifically they are actual owners of the company. And I think that it's important to understand why that matters to the courts as they've interpreted this particular statute. And that is because in those circumstances, there are already pervasive regulatory schemes providing for redress in the event that individuals are harmed by the transactions, either federal or state or a combination of both. In this
Was
case,
was there a pervasive regulatory scheme in White?
yes, Your Honor, because in White, that particular issue involved the same company, and so there were the abilities within the single participant to ensure that any fiduciary duties that were involved were able to be redressed through the standard channels for which a fiduciary could particularly be held accountable in those cases.
As regards your usage, as I understand it, of the term insider, how should we look at your contention as to that relative to what the majority is focusing upon, which is the defendant's desire to get an infusion of cash or capital from someone with whom they have a personal, even social relationship?
Yes, thank you for the question. With regards to having a personal or social relationship that did not in any way render her an insider to the company, she did not have any insider knowledge. She was not involved in any of the common transactions of the company. She was as much of an outsider as someone could be who just happened to be targeted by those individuals. So rather than a single market participant who has been privy to the company's operations, she was simply sought out for capital in some form or fashion.
Am I correct that the primary business of the company was a trucking business? Is that right?
Chief Justice, it was purported to be a trucking business, and at one time it had engaged in some degree of trucking business activities. The evidence did not show that any of my clients' funds were ever used for a trucking business. The evidence introduced at trial did not indicate that the trucking component of the business was particularly thriving, and in fact had largely dissipated by the time my client made provided the funds that were subject to this transaction. And
If,
so
if the trucking company had bought new tires for their trucks, but then had failed to pay the vendor, is that an unfair and deceptive practice?
the unfair and deceptive practice that we contend existed, and to clarify, I don't think whether this is whether element one, that there was unfairness or deception, has been in dispute since this arrived, since the Court of Appeals arrived at their decision. But the unfair and deceptive, to answer your question, nature of the transaction was to convey to Ms. Noble that this was a thriving trucking operation and that business was booming, when in fact not even the most basic of corporate formalities were being were being observed by these individuals.
But when there's a failure to pay a debt of the business, does that constitute a violation of the act?
Certainly a failure to pay a debt in and of itself does not constitute a violation of the act. That would be far too broad. It has to be something unfair or deceptive. And from the outset of the inception of the instrument and the transaction at play here, there was deception inducing my client in order to convince her that this was a legitimate business concern and that in fact business was thriving. So no, I would not contend, Your Honors, that simply failing to pay a debt would bring something within the purview of the Unfair and Deceptive Trade Practices Act.
So really the question before us is whether a loan is part of building a capital structure or whether it was part of the ongoing business of Foxmoor Group, right?
I would say that that's part of the consideration, but I asked the court to also consider how muddled this particular transaction and the characterization of it has been. Initially, the evidence showed that the capital sought by Foxmoor Group and the individual defendants was going to be more along the lines of a traditional security, but in fact, because of one of the individual's felony statuses, they were unable to conduct it in that manner. And so he changed the language of the first instrument into that of a loan, and therefore that was how they conducted the second instrument. In addition to which, one of the individual defendants created a side agreement to provide health insurance, again, in order to give assurances to my client that her needs were going to be met. When we start blurring these lines, that is when, and particularly when we're dealing with an unsophisticated individual consumer, that is when we start to get into the deception and the unfairness that should bring it within the purview of the act.
Counsel, when you talk about blurred lines, wouldn't you have us then to expand this concept of, quote, in or affecting commerce, unquote, when you've got circumstances that involve personal relationships, social relationships, vis-a-vis our appellate law, which primarily focuses on fairly routine and more complex identifiable business relationships among individuals and entities?
I would say that because these individuals knew about this particular individual's personal circumstances, that made her more prone to victimization in this case. Ordinarily, a sophisticated business actor has the ability to protect themselves, has the knowledge to understand what is a legitimate business practice or not. That's not for individual targeted consumers, which is what my client is. My client was sold something. She was sold the idea that this company existed and was conducting legitimate business, when in fact at the time those were misrepresentations. She bought into the belief that this existed.
Ms. Mason, are you, again, just trying to understand analytically what we've got to decide. I've usually found if I can understand what I've got to decide, I'm more likely to get it right. You've talked a lot about in the last few minutes in your answers to Justice Morgan and the Chief about the nefariousness of the conduct in which the defendants allegedly engaged. Does the nature and extent of the deceptiveness of their conduct have any bearing upon whether this case involves a covered business activity, and if so, why?
Sure. So obviously the nature and extent of the deceptiveness goes to element one most clearly. But in this case, it goes to element two as well, because the failure to define this so clearly should not lend itself towards an exception from the act. The legislature created a broad statute intended to redress wrongs. And over time, exceptions to that have been interpreted by this court, but those exceptions should be narrow. In terms of statutory construction, a great deal of deference should be given to the legislature and its intentionally broad language. If an exception is to be created, it should be clear and define what the nature of the transaction was in order to define how it falls into an exception. The fact that the entire process was so muddled and confused, intentionally so, by the individuals and the company who were purporting or who were creating the deceptive practice should mean that they should not therefore get the benefit of a protection that has not been carved out before.
Ms. Mason, can I jump in for a second? I've got a couple of questions. One, did your client gain any kind of interest in the company?
No, ma'am. No, Your Honor, she did not gain any interest in the company at any time.
Okay. And the other thing, the Court of Appeals said that what happened here, the transaction involved an extraordinary event of internal operating within the business, and the trial court concluded that no, it was a regular business activity, and therefore was covered by the UDTPA. So they can't both be correct. What findings of the trial court would tend to support a conclusion in one way or the other? And if we agree with your analysis, does it need to go back for more findings? Or are these sufficient to reach the conclusion the trial court reached?
Your Honor, I think the first thing I would say is that the Court of Appeals was mistaken in saying that this was an extraordinary event. I do argue that this particular ruling incorrectly and improperly found that this was a security instrument of the type that would convey some ownership or interest on what, again, I have said is an insider basis to my client. The lower court spent a lot of time noting some of the irregularities of how this particular company operated or failed to operate under an ordinary business scheme.
I'm sorry to interrupt you, but when you say the lower court, do you mean the Court of Appeals or the trial court?
My apologies. Thank you. I meant the lower court to the Court of Appeals, so the trial court. I'll try to be clear about that.
Okay, thank you. I thought that's what you meant. I just want to be sure.
In my mind, it was we were talking about one and lower to the other. So I apologize. So yes, the trial court did spend a lot of time determining that that in fact this was not that this was how the company was being capitalized at the time, but that in fact the company itself was not particularly operating at a significant level at the time that the ruling was made, or at the time that the loan, if we'll call it that, was made, that the funds were provided. I'm not sure if that answers your question, Your Honor. If not, I'm happy to consider further.
No, that's helpful. Thank you.
If I could just follow up on that. I guess I'm trying to understand whether this transaction was building a capital structure or just part of the regular business activity. Is that a factual finding that is owed deference on appeal?
We contend that this transaction was not intended to capitalize any legitimate business activity whatsoever.
Right. And my question is that contention a finding of fact?
Certainly, in my opinion, the way the trial court ruled, I'm sorry, Your Honor.
Well, you were starting to answer, but I just to clarify, I'm just asking, isn't that a factual issue, a factual matter?
Yes, that would be a factual issue. Whether the actual findings of the trial court rise to the level of an Unfair and Deceptive Trade Practices Act would be an issue of law. but whether the underlying transactions or the underlying findings were sufficient to rise to that level. First, we have to do things in order, make the requisite findings, and then it would be up to your honors to determine whether that meets the standard for the law as applied.
What evidence was presented to the trial court that supports its conclusion that the conduct was a regular business activity?
I'm sorry, your honor cut off just at the beginning of your question.
What evidence is there that was presented to the trial court to support its ultimate conclusion that these loans were a regular business activity?
So there were 3 individuals whose funds were provided to this company. There was never any evidence with regards to any other investors, but all 3 investors were individuals. The funds, there was never any finding, despite questions posed with regards to whether those funds were used for the trucking business. It's our contention that the funds were used for the business of lining the pockets of the individuals. There were extensive findings with regards to the very personal expenditures that were made from this operating account, and not one dime has been tied to the actual business of the trucking entity. So there were various luxury expenses, cruises, pool purchases, cosmetic surgery. Those were the kinds of things that this business was engaging in, not the business of trucking. And so those types of activity, again, we're struggling to define what the business activity was of this company. And it's my contention that because it's not definable as related to just a basic loan or corporate security in which my client got an interest, but was rather the business of obtaining capital for the purpose of engaging in personal purchases, that was what the company was doing.
Ms. Mason, I have a question. First of all, I have to admit that these defendants certainly are not, their activities were very despicable. However, you opened early on with a comment that the Unfair and Deceptive Trade Practice Act does not apply in certain limited circumstances where there is a regulatory program to protect from that. So my question to you is, since we do have federal securities law and we have our blue sky laws here in North Carolina, are you arguing that they, given the circumstances where these people have lined their pockets, that regulatory scheme is in some way lacking in being able to regulate that kind of behavior? Do you think that's outside of the purview of securities fraud?
I don't believe, and thank you for the question, I don't believe that the conduct of the defendants is what keeps that from being subject to the regulatory scheme. I believe that the nature of the contract between them does not have sufficient regulatory protection under other areas of law.
Well, then let me follow up then, Ms. Mason. Are you familiar with the federal case of the SEC versus Howard, or Howie, or the cases of the SEC versus Edwards? In those cases, they were very similar facts, circumstances to the case here. And I point you to the email where one of the defendants actually set this up. And the federal courts have held that kind of arrangement, and I'm talking about the $25,000 original arrangement, is actually an investment contract subject to the federal securities regulatory program. And by virtue of that, would most likely, in my opinion, may very well be subject to our blue sky laws. So how do you rectify that with the position you're taking?
Well, again, I go back to the fact that this would be more, there were a couple of questions in there, and I want to address them each. You asked specifically about familiarity with the 2 cases that you've referenced, and I don't have those cases in front of me to address this morning in full candor. With regards to the fact that there's a regulatory scheme that may apply to this case, I would argue, Judge, that while that is one important factor to be considered, I don't believe that applies to a situation such as the one before us, nor do I think that it is intended to be the exclusive remedy. This has to do with insider characterization. At no time was my client an owner in this company, nor anything. I do think that the first contract seems to sort of hint that there may be some ownership in a truck or the profits of a truck. It's not very clear, but the second instrument, the second transaction does not.
Thank you.
Ms. Mason, I apologize. I'm going to eat into your rebuttal time, but just so I'm clear, your client extended a loan. Is that right?
Yes, Your Honor, and I'm sorry. Oh, Justice Berger. Yes, there I see you. Yes. Well, that's the question. Was it a loan? There's a promissory note to support it, but it seems, again, that none of us are very clear on what exactly it was. Was it a loan? Was it a security instrument? This is the product of an unsophisticated consumer being targeted. That's my point.
Right. And if there's a note, that note is at least some evidence of an indebtedness. Is that correct?
Correct.
And you agree that securities transactions are not business activities under HAJMN?
I would, yes, as I think the court is stating it, I think I would agree with that contention.
So if we were to determine that the note here is an evidence of indebtedness and that it is in fact a security instrument, then your client cannot prevail. Is that right?
I don't agree with that because I don't believe that this is a security instrument. I don't believe that simply because it is a note or could be characterized potentially as a note that it necessarily becomes a security instrument. There are indebtednesses that are security instruments. We contend this is not one of them. By its very definition, there is no security to it.
Okay, thank you.
Thank you. With that, I'll conclude my remarks unless the justices have further for me.
Thank you, counsel. We'll hear from the FLE.
Thank you, Your Honor. May it please the court, I'm Jim Lee representing Dave Robertson. In listening to this discussion, I think we've hit directly on the point that I am trying to make and I think the Court of Appeals made. I will later on address the first part of the argument that the appellant has made, but I want to start first with what I think is the crux of the issue, which is raising capital and internal operations of a single business, such as removing a security from capital structure, an unfair and deceptive trade act. And I think case after case, including two out of the Supreme Court, have made it clear that it's not. Skinner, in 1985 Supreme Court case, involved a purchase and retaining stock to raise capital on the basis that inside information would increase the value of stock. That was held to not be an unfair and deceptive trade act. Hajim, which is Ms. Mason has referred to, is almost, I think, directly on point. In that case, a revolving fund. In other words, a large amount of money was put into Rayford as sort of a security blanket if they ran out of money and needed a fund to go into during that period of time. One of the plaintiffs in that case was never paid back. And the court treated that as a security. That was an amount of money that was placed into the business. Oberlin, I think, is even more analogous to this case because it's actually a loan. In that case, a debtor, a loan was made by the creditor to the debtor in exchange for a later right to purchase stock somewhere down the line. Turns out in that case that the debtor did not reveal to the creditor that there had been a third-party contract that was in breach, which caused him to declare bankruptcy. That was held to not be an unfair and deceptive trade act. I will say from the beginning, and with regard to one of the comments one of the justices made, I'm not thrilled with any of these people involved in this process. I mean, I've got to be honest about the entire process here. It's not, I just got to say, all of them, and I would contend the plaintiff is part of it, are engaging in something that appeared to be too good to be true. And when it appears, that old axiom, when something appears to be too good to be true, it usually is. And I would make that point. about this. When you look at this promissory note in this loan, it's just fantastical how out of the range it is of any normal loan process. I mean, you're talking about what equates to essentially 124% interest on a $75,000 loan paid out over 4 years. Now that the plaintiff is not an unsophisticated investor if she is coming in and receiving $3,500 a month for a period of 4 years on a $75,000 loan. The first loan was very simpler. It was barred, very similar, is barred by the statute of limitations. But this loan, just the terms and conditions of it are almost beyond outrageous.
Mr. Lee, I'd like to ask a question. Are you now arguing that it is somehow the plaintiff's or the appellant's fault because she believed your client?
No, ma'am, I'm not arguing that at all. I'm not blaming her at all. I don't think it's her fault, but I think anybody that's sophisticated, and you got also remember, Your Honor, that in the past, these people had been friends. They had engaged in business together previously. They had done things together, gone on trips together, were very close. And so I think what was happening here is a group of friends were trying to maximize her profit to help her out with regard to her investments in this matter. So I'm not blaming her, nor am I absolving my clients, or my client in particular, Dave Robertson, from the activities that took place here. I'm just saying that they're not an unfair and deceptive trade act. So again, back to the note.
Mr. Lee, let me follow up on sort of a variant of that question for a second. Let's assume hypothetically that, and I'm not going to comment on whether it would have been wise for a bank to have done this, but let's assume for purposes of discussion that your clients had entered into exactly the same promissory note with a major financial institution, not another individual. Would that make a difference in the outcome in this case or not, in your view?
I don't think so. I think it's always going to go back to the fact that this was a loan to capitalize the company. That's an exception to an unfair and deceptive trade act, whether it's a bank. Let's assume, I'm trying to understand sort of the parameters of your argument here. Let's assume that we had a loan that was made for the purpose of providing working capital, i.e. that the money was to be spent to pay ongoing routine and ordinary business expenses until the income derived from those activities came in. Would that make a difference? If it was a loan for that purpose?
Yeah.
Yeah, I think it makes a difference because you are capitalizing a company to conduct their business. So yeah, is
your argument then that the crux of whether we have a covered business activity here depends upon what was the purpose for which the loan proceeds were provided?
No, I'm not completely focusing on that because when I look at the promissory note here, it looks to me like it's has a dual purpose. One is to provide capitalization to the business, but the other is to provide a tremendous, I guess, income to the plaintiff over a period of time. In connection with the promissory note, I hope you'll note that it's something Ms. Mason mentioned earlier, and this is when we get to the point about the first part of our argument, which indicates that she was not an insider or not involved or not an employee of the company. On 5/24/2012, the same date that the promissory note was entered, they entered into Mark Griffiths and Loretta Noble signed this statement. It says, I, Mark Griffiths, having employed Loretta Schwartz Noble, agree to a financial contract of 4 years health insurance in lieu of salary. This contract renews at a rate of $3,500 per month for so long as such time as Loretta Schwartz Noble continues in her desire for employment. That was signed the very same day as the promissory note. So you have not only the fact that this is a loan to the company but that she's actually being employed by the company so she can carry health insurance. What her role
Is there any evidence that Ms. Noble ever performed any work at all for Foxmoor?
No, sir. There was no evidence. I'm being candid with you. There was no evidence.
Is there any evidence that tends to suggest that she performed any of the functions normally performed by an employee of a business?
No, sir. There's no evidence of that.
So why, given that, what import should we give to the existence of this contract saying you're, in return for your employment, you're given health insurance?
Well, the import you should give to it is that it's in connection with the promissory note that was signed at the same time. When she's lending money to the business for its business operations and signs a promissory note, it's a loan. It just lends credence to the fact that these people were intertwined with each other, knew each other well, and were trying to help each other out, not just the plaintiff to the defendants, but also the defendant, Dave Robertson, to the plaintiff. I would also note, my client is Dave Robertson. He is nowhere to be seen on the promissory notes. He is nowhere to be seen except for one check that was written to reimburse Ms. Noble for $7,000 after this transaction took place. None of the evidence at trial indicated that he had spent any of this money whatsoever. And there's the emails back and forth between the parties is between Mark Griffiths on behalf of Foxmoor and Ms. Noble, and nowhere to be seen as Dave Robertson's name on any of that, any of those transactions.
But in light of that fact, are you arguing that potentially there might be a different outcome with respect to your client compared to Mr. Griffiths?
Yes, sir.
Based on what, given that the issue here was a covered business activity involved?
Well, I'm just saying if the court finds, I'll go back to the basic premise. I should have answered your question a little bit better than I did. I'll go back to the basic premise that this is a loan to a business. And if we are going to start taking loans to a business, whether they have a tremendous interest rate to them or not, if this becomes an activity that's subject to unfair and deceptive trade acts, then we're going to open up the floodgates to every single loan that's made to a business. I have to deal with it every day in my law practice of predatory lenders or people that want to lend you money. You see it in business activities all over the world right now. We cannot extend Chapter 75 to the loan process that's going on all over the country with businesses. That's just we're opening up floodgates if we do something like that.
So if I understand you correctly, then is your argument that no loan is covered? It doesn't matter what the purpose of it, whether it's to create capital, whether it's to be a regularly monthly operating expense, cover operating expenses. It doesn't matter what the purpose is. Any loan to a business is not covered by the Unfair and Deceptive Trade Practices Act?
I'm thinking is what I believe is going to have to be some really extraordinary circumstances, which I quite frankly can't think what that would be right now, that would bring a loan or the other activities that we've looked at over the years, exchange for security, exchange for stock, anything that infuses capital into a business is, I think, outside the parameters of Chapter 75. So it's very hard for me to get my head around what circumstances that a loan to a business would fall under the Chapter 75 parameters.
But where in the text of the statute do we draw the conclusion that loans cannot constitute a regularly a business activity that affects commerce?
You know, I don't know if you can read it straight from Chapter 75, but the case law that's interpreted the Chapter 75 over the years has made it very clear that the loan is a exception to the rule. Quoting again from Hajim, raising capital in internal operations of a single business, such as removing the security from the capital structure, does not fall within Chapter 75.
Right, so your position is every loan is raising capital.
If you are borrowing money to infuse into your business, yes, ma'am, every loan is raising capital to move ahead with your business.
And it doesn't matter that in this case, they actually weren't using the money to run a business. They were using the money for their personal expenses and cruises. That actually doesn't matter. It's just what they stated the purpose was.
Well, not all of that money was used for those purposes, but when you say there's very little evidence that Dave Robertson used those loans for any of those purposes. It was Mark Griffiths that used the loans for those purposes. And there was money that was put into the business activities. I don't sanction at all Mr. Griffiths' activities after that point. I'm telling you, I'm very honest about my clients. I always am. I'm just saying that this whole thing does not look good overall, but it's not a Chapter 75 violation. I mean, this happens a lot.
But,
Yes,
but
something. I'm sorry, go ahead.
no,
Go ahead.
please.
I'm just, if your argument is that that this happens all the time, that there are loans to businesses and that can't be covered by Chapter 75, aren't you essentially arguing that giving or loaning money to a business is a regular business activity that happens all the time? And if it's a regular business activity, doesn't that bring it within the scope of Chapter 75?
Well, you would say that if the previous case law had not said different. I mean, both Supreme Court cases have dealt with this very situation and said that if you're raising capital to inject into a business, it's not a Chapter 75 violation. And what I'm saying, if we start taking loans to businesses and if we don't like how they came out and we treble damages as a result of that, that's a slippery slope that we're heading down.
Well, there is an exception if you're sort of loaning money by purchase of securities of some kind. But I was looking at the promissory note here, and aside from where it says at the very beginning, the boilerplate for value received, this promissory note doesn't indicate that she's getting anything in exchange for that. Is that right? Is that a correct reading of that?
Well, with all due respect, Your Honor, I think she's getting a tremendous benefit from this because had it gone through and they attempted to pay it for a couple of months before the business collapsed, but when you're getting loaning $75,000 and getting $35 a month over a 4-year period, that's a tremendous benefit you're getting returned for that.
Isn't that just paying back the loan?
You're paying back a loan at 124% interest.
But she's not getting any interest in the company, though, in exchange for that, is she?
No, but she's getting what would be flow of income from the business at $3,500 a month. And that's a risk you take when you're asking from both sides. If you're going into a company, you're going to lend money at 124% interest, you might be taking a risk by doing that. It's not a Chapter 75 violation.
Okay, thank you.
In asking us to apply the standard appellate case law principles to this case, are you impliedly expecting us to ignore the peculiar facts of this case as to what your client, coupled with the defendant Griffiths, has done concerning having this plaintiff to be listed as an employee when in fact she wasn't, according health benefits to her when in fact she was never given any? Said another way, are we just to ignore those peculiar facts and just concentrate on the standard appellate law when the appellate law doesn't have those kinds of aspects to it?
Well, if what you're saying is that even though I think what you're saying, Justice, is that even though this was clearly a loan, clearly the interest rate that is at, clearly a payback, that this would be somehow different from capitalizing a business. I just don't think it is. I think there's unusual circumstances to it in a way, and not terribly to the benefit of my client, Dave Robertson. I mean, when you're borrowing money at that interest rate and promising your creditor those type of things. You know, I think it's a fact situation that they're all going to have to live with. It's
Well,
not-
to use a colloquialism, your client, coupled with Mr. Griffiths, laid out the playing field upon which the plaintiff would operate with them. And it appears as though you're desirous of this court ignoring the aspects that came with that and just want to have us to apply the standard appellate law that relates to Chapter 75 and get the benefit of that while similarly ignoring the aspects that you candidly admit are difficult circumstances to be defended.
And what I'm saying candidly is that all three of these people are involved in these transactions. They are long-term friends. They had been on trips together. They had been involved in things together. They all went in with eyes wide open into this transaction. So I don't think that this makes this as nefarious as some may say. I mean, they are all intelligent people that entered into a promissory note. And I think that buttresses the argument, doesn't negate from it, that this was a loan that was made to a business with an investor that fully knew what she was doing. And I don't think it takes it out of the parameters of the exception to Chapter 75 at all.
It appears to have turned nefarious when the plaintiff was told, however, that if she expected to get repaid, that the company would declare bankruptcy and she would get nothing.
And I'm sorry, Your Honor, your question is?
I didn't put a question mark after it, but I didn't know if you wanted to respond to it or not, but I put a question mark to it. How do you respond then to your depiction that this was not nefarious when in fact the plaintiff was confronted with the notion that if she decided that she was going to impress upon the defendants that she expected to get repaid, that she would lose everything because the company would declare bankruptcy?
If a company gets itself in a position that it cannot make a $3,500 a month payment and they're saying, will you accept less, or can we do something? Can we defer it? I don't think that's out of the normal for any company in dealing with a difficult financial situation. It's also the exact fact situation in my mind in Oberlin, in which, in that case, I've talked about that earlier, the creditor lent money to the company for a later right to purchase stock, and that debtor in that case did not reveal that they had a breach of contract and were near bankruptcy. And that was not held to be unfair and deceptive trade act. I think that's very similar fact situation to your question, Justice Morgan.
It just sounds like on one hand, you're depending upon the fact that they were friends and social and personable with one another, but yet ironically, when it got to the point where the plaintiff was about to enforce the promissory note, it began to smack of being a business relationship that was going to be treated as such in terms of bankruptcy potentially being declared. She would lose everything, and as a result, sounds more like it could be construed to be a business relationship that could be subject to the UDTPA. What is your response to that? I'll make sure I put a question mark behind it this time.
Right, Justice Morgan, I appreciate that. Once again, I have to disagree. Go back to the notion again that this is a promissory note and an infusion of capital into a business. There's been time and again in our appellate courts held as an exception to Chapter 75. That's just what this is. It's that simple. It's a promissory note, the terms of which I've commented on earlier, but it's an infusion of capital into a business, and that's been held to be an exception to Chapter 75 time and again.
Can I just ask you about that point? Because
Yes, ma'am.
isn't there a crucial difference in that this transaction is not subject to regulation by securities laws?
But I don't think I know that case that you're talking about, and I know that one case says that we have here that says if there are other regulations out there covering these types of things, that I don't think that takes it out of Chapter 75 because there may not be other remedies. There are other remedies, fraud, or whatever you want to, all the claims that were brought. It's just you get to the point you treble damages under Chapter 75, and I don't think you
Right,
get.
but you have been telling us that we have previously held that loans are not covered, loans to businesses are not covered by Chapter 75, but the case you're relying on, HAJMM, was based on the rationale that secured transactions are subject to regulation by the SEC and by other state laws. And this transaction, if this plaintiff wanted to file a complaint with the SEC, this promissory note would not come under their jurisdiction. They wouldn't give her any relief. They're not regulating this promissory note.
Well, I don't know that. I don't know that it wouldn't be, and I defer to you, Justice Earls, with regard to that. I would say that the Oberlin case, again, I keep going back to this, sort of an extension of Tajam. And then again, it involved a loan from a creditor to a debtor based on some representations that were made by the debtor that were not true. And so that case held that that is not an unfair and deceptive trade act because they were capitalizing the finances of the company.
Mr. Lee, if I could jump in, if this is a security as defined by the North Carolina Securities Act, and this is in fact a securities transaction, would finding for the plaintiff in this situation require us to overturn HAJMM?
I think so. Yes, sir. I think you would have to overturn the holding in that case. If there are no other questions, I conclude my comments at this point.
Thank you, counsel. Rebuttal.
Thank you, Chief Justice and fellow justices. Simply would state in rebuttal that we've relied in part upon an employment contract, an alleged employment contract that in fact did not exist in terms of actual employment and other surrounding activities. And all of this goes to the fact that, and one of the justices asked earlier with regards to findings of fact by the lower court, this was not a security in a company that was engaged in trucking. This was a desire to drive up capital for personal expenditures. The lower court acknowledged, the trial court acknowledged that it could not determine from any of the evidence whether any of these funds had been used for trucking purposes. And therefore, that is my contention, the basis of my contention, given the substantial amount of personal expenditures, that this company was in the business of soliciting funds for inappropriate purposes and not.
Well, it's so Ms. Mason, to go back to the discussion that you and I had during your opening argument, is it your contention then that the extent to which a business is involved, if that term is used in 75-1.1, depends upon what use the money is actually put to?
I think it's extremely relevant what the money is put towards when we're considering whether or not this is a security instrument versus the ordinary activity of the business. Yes, Your Honor.
Ms. Mason, I want to follow up on the question that I asked Mr. Lee. Would you agree with him that if this is a security as defined by the North Carolina Securities Act, and this was in fact a securities transaction, that finding for your client requires us to overturn HAJMM?
Yes, if the court If the first premise is true, I would agree that HAJMM would be overturned.
Under NCGS 78A-2, security is defined by statute as any note, evidence, of indebtedness, or generally any interest or instrument commonly known as a security. Would that definition change your answer in any way?
Well, again, Your Honor, I want to distinguish between a security in what. If this is deemed to be a security in this trucking business, then that would be a definition that would apply to this transaction. It's my contention that this is not a security in that business. This is a security in nothing. This is a security in personal expenditures. And so I agree that if the court defines this as a security in that particular trucking entity, that HJMM would be troublesome for my client. Justices, I thank you for your time today.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Thank you, Your Honors.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court. Thank you, counsel.
Thank you, Madam Clerk, for your help this morning. Thank you, Mr. Wood.
Thank you, Madam Clerk, Mr. Wood. Thank you. Good seeing you, Amanda.
To Jim.
Amy, I'm trying to get my mouse to work. It'll give me